Very good, thank you. I welcome members to the 10th meeting in 2016 of the Delegated Powers and Law Reform Committee, and as always ask members to turn off mobile phones, please. Agenda item 1 is instruments subject to negative procedure. The Town and Country Planning General Permitted Development Scotland Amendment Order 2016 SSI 2016-126. This instrument contains a drafting error. Regulation 3.2 of the instrument substitutes Class 6H of Part 1A of Schedule 1 to the Town and Country Planning General Permitted Development Scotland Order 1992. The word if has been omitted from the provision at the beginning of subparagraph 2D of that class. The committee may wish to note the Scottish Government intends to correct this error at the next available opportunity. Does the committee agree to draw the instrument to the Parliament's attention under the general reporting ground in respect that it includes a minor drafting error?
Yes.
Thank you. No points have been raised by our legal advisers on the non-domestic rates renewable energy generation relief Scotland Amendment Regulations 2016 SSI 2016-121, nor the non-domestic rating unoccupied property Scotland Amendment Regulations 2016 SSI 2016-124. Is the committee content with these instruments, please? Thank you. Agenda item 2, instruments not subject to any parliamentary procedure. The Acta Sederant Rules of the Court of Session 1994 and Sheriff Court Rules Amendment Miscellaneous 2016 SSI 2016-102. This instrument contains 2 errors. New Rule 33A 21.6 of the Ordinary Cause Rules, as inserted by paragraph 3 of the instrument, makes reference to a child welfare officer. The correct term is child welfare reporter. Paragraph 5 of the instrument makes a saving provision preserving the effect of the ordinary cause rules as applied immediately before the 21st of March 2106. The correct reference is, of course, the 21st of March 2016. The committee may wish to note that the Lord President's private office intends to correct both of these errors at the next available opportunity. Does the committee agree to draw the instrument to the Parliament's attention under the general reporting ground as it contains errors?
Yes.
Thank you. No points have been raised by our legal advisers on the Air Weapons and Licensing Scotland Act 2015, Commencement Number 3 and Transitional Provisions Order 2016, SSI 2016-130, nor the Air Weapons and Licensing Scotland Act 2015, Commencement Number 4, Transitional and Saving Provisions Order 2016, SSI 2016-132. Is the committee content with these, please?
Yes.
Agenda item 3 is the Higher Education Governance Scotland Bill, and this item is for the committee to consider the delegated powers provisions in the bill as amended at stage 2. There is 1 revised power in the bill. 4 delegated powers have also been removed from the bill, which the committee had reported upon at stage 1. The committee may wish to welcome both the removal of these powers and the inclusion of further detail on the face of the bill. Does the committee agree to report that it is content with the delegated powers as amended at stage 2?
Yes.
Agenda item number 4, Private Housing Tenancies Scotland Bill. This item is for the committee to consider the delegated powers provisions in the bill as amended after stage 2. At stage 2 there was 1 new power and 2 revised powers. The revised power in section 32 of the bill allows Scottish ministers to designate a rent pressure zone. The bill has been amended at stage 2 so that the procedure to make regulations to designate a rent pressure zone is restricted to when the zone is first so designated, and any subsequent revocation or amendment of the zone is subject to the negative rather than the affirmative procedure. The justification for the change provided by the Supplementary Delegated Powers Memorandum is that there may be a need to respond quickly to market conditions and that the affirmative procedure would be a barrier to expeditious action. The committee may wish to have regard to the steps that are taken before a rent pressure zone can be designated by Scottish ministers in regulations, including being subject to affirmative procedure, and may wish to consider that a similar level of scrutiny by the Parliament should be available when it is proposed that a rent pressure zone is amended or revoked. The committee may consider the provisional affirmative procedure would provide adequate scrutiny and also meet the Scottish Government's needs. A model is found in section 68.4 of the Land and Building Transaction Tax Scotland Act 2013. This procedure would allow regulations to be made and, if necessary, have effect during periods of recess. Members have several comments. John.
Yes, I think I agree with that because, it does seem to me that there are quite considerable steps to be taken before the initial designation can be made, And while a subsequent step might be minor, it could also be major. And if it's undoing the whole of a rent pressure zone, that is, in my opinion, a major step, and so would require the provisional affirmative procedure. So I support that.
Thank you.
Clearly, the government could take a number of approaches to this. One that occurs to me is they could perhaps restrict the power under the negative procedure to orders which only have effect for a limited period of time, say, for the sake of argument, 60 days, giving them time to bring forward an affirmative procedure. I'm not saying what they should do, but I'm saying that I share the concern that my colleague John Mason has expressed, that we could see something as substantial as the original order being dealt with by negative procedure. I understand the issue about urgency, but I think there are other ways of dealing with it that the government should consider.
Yes. John?
I would just be supportive of what my colleagues Stuart and John have said. I think this is a very big step to amend or revoke a rent pressure zone. And I think the procedure needs to be an enhanced procedure rather than just a negative procedure. So I would be content and supportive of their comments as well.
Leslie?
Can I maybe ask a question as well? Because I am supportive of the comments from changing it from a negative to an affirmative. Because I was just thinking of in section 32(3), it says about the zone would cease to have effect after 5 years. And I just wondered if they had amended it under the negative, would that then, if it was nearing the end of the 5 years, would that then extend? I just think I think the affirmative is a better procedure, so it gives proper scrutiny.
I'm very happy to ask that question. If the original order was for 5 years and we amend it part way through, does the amendment run for 5 years, or is it merely an amendment of the original 5-year period?
Looking at it, yeah,
sorry, I just thought of that question.
Oh, that's a good question.
Looking at it cold there, I think the original 5 years would run, but I'd need to look at it properly. This issue's first come up now, so I think I'd want to consider it. But I think the 5 years would expire on the original regulations, looking at it that way.
Either way, it doesn't seem unreasonable to read this as an opportunity to bring an extremely strong procedure for one street, in theory, and then have an amendment which would cover the whole of a town. Now, I'm not arguing the government would do that, but it seems a strange way to set up the law. I mean, that's to expand it to the whole of a town rather than just take it away from the one street. So it rather looks as though this amending procedure is rather underweighted. So, does the committee agree that a change in procedure for regulations under Section 30, which amend or revoke a rent pressure zone from the affirmative procedure to the negative procedure, is unacceptable? I think that's what we are saying. Does the committee agree to recommend to the Scottish Government that the provisional affirmative procedure may be more appropriate, and to suggest a model similar to that when Section 68(4) of the Land and Building Transactions Scotland Act 2013 should be adopted? Sorry.
Yes.
Yeah. Okay. In which case we'll go with that. Yes. Thank you.
Convener, can I ask, wanting us to approve that if the government doesn't propose an amendment, that we would actually put forward an amendment at this stage, or would that be a decision we made at another time?
I think it's an interesting discussion to have now. Thank you for raising the issue. I mean, how do we see this?
Well, I mean, I think my inclination would be that if the government doesn't propose an amendment, that we put forward our own amendment.
How do colleagues feel about that?
I agree with the principle of what John's saying. I think we should allow the convener, in the light of what emerges, to make that choice, because I think I trust the convener. So I think we don't go away tying the convener's hands to must do it if the government doesn't do it, but to look at what's happened and take soundings from members of the committee in an appropriate way. But we empower the convener to do that if his soundings of committee members, once we see what's brought forward, suggest that's the right thing to do.
Other members have any view? I'm very happy to take the soundings now, because I think there are various ways of tackling this.
I think I'm supportive of what John Mason said about actually, I think if the Scottish Government don't bring forward such an amendment, that we do put it forward as an affirmative. And we have a meeting on Thursday, so actually, will we know the Government's amendments by then?
Not necessarily, I'm told, which is why I think, given the general timescale of this, it might be wise if we did something proactive. Maybe I should be writing to the government, laying out our concerns. As always, I'm sure somebody will be watching us as literally as we proceed. But I think if there is a general concern about this, because there must be some options as to how the government could handle this. One would be to give itself a different kind of power if it is something minor. Secondly, to give itself a different kind of power if it is merely to revoke something that already exists on a small scale. But on the other hand, if revocation is as significant as setting it up in the first place, then maybe even that's not logical. I'm in members' hands. I'm quite prepared to write to the government pointing out that we think there's an issue here. John, please.
I think that would be the logical first step, to write to the government. As you say, the government will doubtless be watching these proceedings, intimate that we're unhappy with what they're proposing in the letter formally. I'm certain discussions can take place between our advisers and the government in the meantime, and if the government don't wish to bring forward an amendment, then we should perhaps reserve the right to do so.
Well, we certainly do have the right to do that. We don't need to reserve it, do we, John? Right. Do colleagues have anything to add to that, or I will pursue those thoughts in writing, and no doubt there will be discussions between legal advisers and...
For clarification, so you're going to write to the government and lay all that out?
I think I'm going to write to the government to lay out the general issues as we've raised them.
And we'll see what happens, but I mean, following Stuart's suggestion that you are empowered to put down an amendment if we're not satisfied with the response, I mean, I would certainly endorse that.
Well, thank you. I think if there's any indication by Thursday that we need something to discuss, then I'll make sure we've got something positive to discuss on Thursday.
Right.
Yes,
okay.
The clubs.
Sure. Yep.
Yep. Okay, thank you very much. Does that cover that? I think it does. Agenda item 5 then is the Land Reform Scotland Bill, and this item is for the committee to consider correspondence received from the Scottish Government on expected amendments to Part 3 of this bill. The expected delegated power will enable Scottish ministers to make provision for a public register which will contain information about persons who have a controlling interest in land. It's proposed that regulations should be subject to an enhanced affirmative procedure the first time the power is used, but the implication of the letter to the convener of the Rural Affairs Committee is that maybe it will be the first time and only the first time. And again, we haven't seen the government's proposals yet. Now, can I just confirm that we will have seen that by Thursday? On this particular occasion, we will have seen government proposals by Thursday. But how would members like to take this one forward, please? Stuart?
I think until we see the government's proposals and conclude that we're satisfied with them, we should perhaps at this meeting put on the record that our preliminary view is that subsequent operation of these powers should also be by the same procedure as initial.
I would support Stuart Stevenson's remarks, because we expect that the powers that the government will be taking in this amendment, as yet to be revealed to us, will have very wide powers, and therefore, while we are content that the first use be subject to the enhanced affirmative procedure, I think it would be reasonable, from our understanding of what we are about to receive, so to speak, that subsequent usage should be subject to the enhanced procedure as well.
John?
Yes, I mean, I still have overall concerns about this bill, that there just is so much is being left for regulation and is not going to be in the face of the bill. And I do accept the time pressures, but I mean, somebody made the decision to run with the timetable that is being run with. So, I mean, that's my overall kind of starting point. On the specific issue we're looking at, I agree with my colleagues. I mean, I think the intention is clearly that on the first use, there would be something major happens, and probably after that it would be minor tweaking. And I think my preference would be that the government actually put that in the bill, that in future, once the initial steps have been taken, that in future it would only be minor changes. But given that, assuming that that's not there, then I totally agree that there needs to be greater scrutiny.
But one option, if I'm hearing members correctly, would be that there might be two amending powers, one of which would be for things that were definably minor, and the recognition that if they weren't minor, then they should have some kind of enhanced form of scrutiny, but that if they were minor, that it would be actually crazy to force that, and it ought to be possible to have some short system. Stuart?
It may be that we would conclude in relation to there being two processes for major or minor, that there should be a case for Parliament being party to making the decision as to whether they are major or minor, rather than it merely being at the hand of ministers, because we are talking about a major policy area.
Yes. Yes, Leslie.
Yeah, I think there's been a number of concerns about the lack of policy development on this bill, and I think we would want to have clarity about going forward for the development of the regulations. So I think it would be good to have that clarity around whether it was a major amendment of the sort of second and subsequent iterations, or if it's a minor. I think we need that clarity, given that there are a number of concerns about the lack of policy development.
Yeah, John?
I would echo what my colleagues have said, and just add to it a little, in that this has been one of the sections of the bill where we've had ECHR concerns as well. We're looking at this very late stage at major policy being left to regulation, which may or may not, given the government's track record in this area, may or may not be compatible with ECHR, and therefore, in terms of balance, because that does seem to me one of the important things in ECHR, of the rights of the individual versus the state, then it must be given, at the very least, the amendment to be brought forward must at least offer the maximum level of scrutiny, so that any mistakes that would bring the Parliament into disrepute can be avoided.
Right, I'm just wondering how we should take this forward, and again, the timetable is short. I'm wondering whether again I should suggest to the committee that I should be writing to the government, pointing out the tenor of this discussion, thanking them of course for the letters to myself and to Rob Gibson, and expressing some concern that whatever amendments they bring forward or proposals they bring forward should be appropriate to whatever amendment it is they're trying to make to those regulations. Because there is a risk that if we asserted that it should always be an extended enhanced procedure, that would be totally over the top on some occasions, but equally to take the reverse view would be inappropriate on other occasions. So I suggest I need to try and get the government to see if they can get their minds around a way of doing something which is appropriate to the level of amendment at the time. Leslie?
I think a letter would be, given the very tight timescales, I think that would be I think that's a good step forward. Yep.
Okay. John?
Yes, I would endorse that, and I mean, I think my preference would be that they actually do spell out in the bill that the first time would be major and other times might be different. But if that's not the case, then the scrutiny side needs to be changed.
Yes, indeed. Well, of course, we do get an opportunity to do this again, look at this again on Thursday, by which time we will have the government's current proposals. So it suggests my letter needs to go off pretty promptly this afternoon to make sure that, again, that they've got something to work on, proposing that I would copy the Rural Affairs Committee into that letter as well, or at least the convener, so that everybody's in the same place. Right.
Just add that we would be happy that we don't necessarily personally need to see that letter, that we were happy to delegate that power to you.
Thank you, but I'm sure you will see a copy, but possibly it will have gone before you see it.
Yes, absolutely.
In the context. Thank you. Right, I think that completes it into agenda item 5, if we're comfortable we've made every decision we need to make, which takes us on to agenda item 6, which is the Scotland Bill. Thank you, Rebecca. Under this item, the committee is invited to consider the powers to make subordinate legislation conferred on the Scottish ministers in this bill. A briefing paper has been provided that sets out the relevant aspects of the bill and the comments on their effect. Does the committee agree to recommend to the Devolution Further Powers Committee that in relation to clause 7.14 of the bill, the power conferred upon Scottish ministers by virtue of section 1552A of the Political Parties, Elections and Referendums Act 2000 should be subject to the following procedure: that the order should be laid before Parliament and not subject to further procedure in accordance with section 32 of the Interpretation and Legislative Reform Scotland Act 2010.
Yes.
Indeed. Does the committee agree to recommend to the Devolution Further Powers Committee that in relation to clause 38.10, powers conferred upon Scottish ministers to commence certain provisions of Part 1 of the Equality Act 2010 should be subject to the procedure which normally applies to a commencement order, i.e. that the order should be laid before Parliament and not subject to further procedure in accordance with Section 32 of the Interpretation and Legislative Reform Scotland Act 2010?
Yes.
Thank you. Does the committee agree to report to the Devolution Further Powers Committee that it is content with the remaining delegated powers conferred on Scottish ministers in the bill and with the procedure to which they are all subject?
Yes.
Thank you very much. I think that completes the agenda, and I close this meeting.